Welcome to CNN Live's daily report on the extradition hearing of Julian Assange at Old Bailey in London. I'm Joe Lauria, the editor-in-chief of Consortium News. Well, today was a jam-packed day of testimony. It's impossible to summarize everything that happened. Court has only ended about an hour ago. I'm going to do my best. There are several issues here, all of them significant in their own right. The most complex and substantive part of today's testimony was by Carey Shenkman, a civil rights attorney in New York, who was extremely combative with the prosecutor, Claire Dobbin. It was a masterful display of lawyers trying to out-lawyer each other, and Shenkman may have done that. As a layman, I'm going to do my best to summarize that. But the testimony began this morning with Nicky Hager, that's how he pronounces it. He's an investigative journalist in New Zealand. He testified, like other defense witnesses have, that Julian Assange took extraordinary precautions in redacting the names of informants from WikiLeaks documents before publication. Now, we again are on the issue of informants, which the U.S. has zeroed in on. They are only charging him with publishing those documents, although he's charged in numerous other counts of receiving and possessing defense information, classified information. They're zeroing in on this informants issue, as we've been talking about. Hager spoke about how important WikiLeaks releases were in his work as an investigative journalist, particularly in a book called Hit and Run, about the conduct of a New Zealand special forces in Afghanistan that led to an inquiry in New Zealand. And later he was cross-examined about that because this inquiry said that they got some things wrong. Of course, the prosecution tried to present that James Lewis as if he got it all wrong, but Mr. Hager was very good about taking his position that, in fact, most of what they had reported was found to be credible by the inquiry in New Zealand, and they got only a few things wrong. But he credited WikiLeaks, of course, for the enormous help that those releases in Afghanistan gave him in his work, and he worked directly as a partner with Julian Assange. He was given about 400 documents, I believe, to go through and redact himself. The prosecution tried to say that he wasn't qualified to do redactions and he didn't spend enough time, only a few days, on these hundreds of documents. And Lewis pointed out that Stefania Morizzi, the Italian journalist who will be testifying at some point, has said in her written testimony that she and another journalist spent 9 months on 4,000 documents to try to show that Hager really didn't do such a good job. And again, trying to portray Assange as somebody who was recklessly publishing this information. Hager pointed out first that he, in his interactions with Julian Assange, that he wanted to say that the portrayal of his character in the media was completely at odds with his time spent with Assange, that he was a humorous and serious person, and it's completely foreign way he's being portrayed, and that he even had problems with his colleagues and friends and the family to convince them that Assange was not the monster that he's portrayed as. But I guess it wasn't very successful. The documents that he used again were redacted, and the prosecution tried again to bring up this dinner. And I find this really something because if you recall, on Wednesday, John Getz, the German journalist who was at this dinner at the Moro restaurant in London, where David Lee and Luke Harding, which is along with Gordon Kromberg's affidavit, clearly the favorite reading material of the prosecution, because they refer to it repeatedly throughout these first 2 weeks, which concluded today, Friday. That at that dinner, apparently Assange said it didn't matter if informants were killed, they deserved it. Now, Gertz was not permitted to be questioned on that. That was a key moment in testimony on Wednesday, so it still hangs out there in the court that Assange may indeed have said that. Of course, Gertz has signed a statement, and he said in press reports that Assange never said that, but he was not allowed to put that on the record for the benefit of Judge Vanessa Barreza. There was also the issue of the Frontline Club that Lewis brought up on a press conference in which Assange said to the words to the effect that WikiLeaks is not obligated to protect other people's sources from unjust retribution. A part of that sentence that Assange uttered that the prosecution obviously did not want to highlight. Again, they want to portray him as a reckless man who didn't care about people dying from the publications of WikiLeaks. On cross-examination, it was brought out that there have been cases where the press has published names of informants when those informants were known to have been adjunct provocateurs who had committed committed crimes. Hager responded that that was an ethical sharp edge of an ethical question of journalism. They didn't really want to get into, but the point was made that in certain circumstances, informants, the press has published the names of so-called informants when they were misbehaving in egregious ways. Northern Ireland was pointed out by the defense attorney to show that that had happened before. Essentially, the issue of the redactions or not was at the heart of the testimony of Hager, and the government again is trying to portray Assange in a certain way, and the defense is saying that it's not true, that in fact it was David Lee and Luke Harding who first put out the password to the unredacted State Department cables that were then published first by Cryptome in the United States, and the next day was released by WikiLeaks. But they're not accepting that. The government says that Assange put out in August another 133,000 documents. They allege there are informants' names in that. The defense has said that those were not classified documents, and apparently he's not being charged for those. So that was Hager's testimony. Again, going over this familiar territory of the informants still being the main issue for the government, and everything that the defense has said, of course, has not changed their opinion about that. So this is a key part of our hearing. We then broke, and when we came back, this extremely interesting witness, Khaled El-Masri, was actually trying to log on through the court's online video link system, and he was unable to. And I think it was Mark Summers who said he regrets that something like Zoom could not be used for this testimony rather than this more highly complex court video system. Yates did not respond to that, but it was put out there. So instead of him testifying, and in fact, James Lewis, the prosecutor, jumped to his feet to object that he should be testifying at all, saying that it was irrelevant. Clearly, the information that we're going to hear, I'm going to tell you about El-Masri, was not something that the United States or its British attorneys want to be heard in a British courtroom. It's rare to hear the kinds of absolutely proven horrendous misconduct of the US government in Afghanistan in particular, and in this case of El-Masri that we heard in this courtroom today. Alexander Makuris, the legal analyst who's been joining us on our weekend shows, said that in, again, Northern Ireland, there have been cases where British government and its army has been accused and in open court of crimes. But this is something I think on a larger scale, because we're dealing with many different situations, Iraq, Afghanistan, and here El-Masri. So to hear the US really raked over the coals by British lawyers in a British court is something you don't read about very often in the mainstream press, except when they published a WikiLeaks story back then when they partnered with them. Usually the role of the mainstream press, unfortunately, is to not ask those kinds of questions, or in effect cover up illegal behavior, even criminal behavior by the government. And that's what we heard about. And that's the case of El-Masri. In fact, there was an Arabic interpreter in the courtroom, and Yates dismissed her because she would not be needed. So instead, Mark Summers, the defense attorney, read the testimony of El-Masri. And this is a man who was Lebanese born, had become a German citizen after living 20 years in Germany, was an upstanding citizen, according to Mark Summers. And he was on holiday in Macedonia in June 2014 when he was taken off a bus and kidnapped by CIA agents and sent eventually to a black site in Afghanistan where he was sodomized and tortured. And that was according also to the testimony of John Goetz on Wednesday, the German reporter. Goetz actually found these CIA agents who did this in his investigation. And he wrote a cover story in Der Spiegel that led to a German parliamentary investigation, and ultimately the filing of an arrest warrant by prosecutors in Munich for this CIA team. Because El-Masri being a German, they had jurisdiction over that. But the warrant was never issued for the United States. And now El-Masri never understood why until he read the WikiLeaks cables, the diplomatic cables, in which it was clearly written there in black and white that the deputy head of the U.S. mission, I presume in Munich, but I'm not sure, that wasn't said where, made demarches to German officials that U.S.-German relations would be seriously affected if they went ahead and tried to arrest the CIA men. The thing about Masri was that he was tortured and brought back and released on Albanian territory in the middle of the night. He didn't know where he was. Thought he was going to get shot in the back. So all the horrors that they perpetrated on this guy. And he was released by the U.S. under condition that he did not speak about this to anyone. Well, he violated that. He tried to get accountability. And he finally came to a German lawyer who started to help him. But he was being ridiculed and ignored and not believed in Germany, the things that he was saying in public, until Gertz, the Spiegel reporter, got on the case and did that front page story in his very important magazine, Spiegel, of course, in Germany. And as Summers said, as a result of the cables, it's now known, but it wasn't known at the time of the warrant, that Germany bowed to the pressure not to seek the extradition of the 13 CIA agents. In effect, the US threat also put an end to a parliamentary probe into this. Summers says that the European Court of Human Rights in Strasbourg in December 2012 sided with El-Masri's story and said it was true, and that the Grand Chamber of that court actually mentioned the WikiLeaks cables were relied upon for them to make their judgment. Subsequent Freedom of Information Act lawsuits in the US revealed that the CIA Inspector General had investigated El-Masri's story. This is a guy who's completely innocent, who was on a vacation and was thought to be some kind of an insurgent and was tortured, and then just released and said, don't talk about it. But the CIA Inspector General, their report that was revealed in a FOIA only, determined that El-Masri's torture and detention were unjustified. Even the CIA admitted this was some horrible mistake. So El-Masri, with that information, started a lawsuit in the Eastern District of Virginia, which some has pointed out is the same court that has issued this indictment for Assange, and where he would be tried if he goes to the U.S. El-Masri sued the CIA there in that court in Alexandria, the CIA agents involved, as well as those who controlled them. But guess what? The U.S. attorney in that court in Eastern Virginia declined to pursue the case. So here was a CIA report that showed it was wrong and that it shouldn't have happened. So he tried to sue on that, but the U.S. attorney declined to pursue the case. This is the Justice, Freedom, and Justice for All pursual. Again, another good example in the United States, covering up misdeeds by, in this case, the CIA. So the ACLU initiated proceedings in the Inter-American Commission on Human Rights. That eventually led to the International Criminal Court taking up this case. And they decided March this year to investigate El-Masri's story. And the reaction of Secretary of State Mike Pompeo, he said extreme measures would be taken against the ICC and its prosecutors. And I'm quoting Summers here. Mr. El-Masri said that without the brave exposure of state secrets, what happened to him, would never have been understood. That exposure of state secrets, of course, by WikiLeaks. So here's an attempt by the defense to show the court what WikiLeaks does, what they do for a living, and how they help this individual immensely in order for him to try to get justice. So at least to clear his name. This is one of the main arguments of the defense, what WikiLeaks is actually all about. we then had a break, and next up was a statement read on behalf of Jennifer Robinson, who, of course, is one of the lawyers in Assange's team. And Robinson says in this statement read by someone else of the court that she was invited to a meeting at the Ecuador embassy back in what year? On August 15, 2017. Assange was still in the embassy then. And at this meeting was a sitting U.S. congressman at the time, Dana Rohrabacher, and he came on behalf, he claimed, of President Donald Trump to offer a deal, a win-win situation, that Assange's prosecution would not go ahead. He may even get a pardon if he was able to tell the United States or give evidence that of who the leaker was of the Democratic National Committee emails during the 2016 presidential election. Clearly, with that knowledge, Trump would be able to say that it wasn't Russia, if that's what Assange said, and he has publicly said it was not Russia, but they wanted to know who it was. And Trump would be able to win politically. And also Rohrabacher, who was quite friendly towards Russia for a congressman, that he felt that there was new Cold War tensions between Russia and the U.S. that resulted from this entire Russiagate scandal, and that by Assange giving up the name of who the source was, that could lessen tensions and get Trump off the hook. Sound like a good deal, except Assange refused, and he refused because he won't give up his sources, which is paramount when you're doing the work that WikiLeaks does. As any journalist dealing in these types of stories need to protect their sources. So he refused. The U.S. prosecutor then stood up and said that while he believed that Jennifer Robinson's words were true, not and what happened at that meeting, they did not accept what Rohrabacher claimed, that Trump had sent him there. In fact, Donald Trump later rejected that, denied it, said he was gone. He went on his own. He said, I believe he hardly knew Rohrabacher. He met him a couple of times. Now, who could believe Donald Trump on a story like this? But that was put on the record there. And I think, obviously, to try to show again the political nature of this entire case from the United States. If they were able to make a deal, if the president was going to give him a pardon if he gave up the source, well, how serious are they about this kind of, in terms from a criminal law perspective, to prosecute Julian Assange? The last part was, again, the most substantive part. And this was the resumption of testimony by Carey Shenkman, a civil rights attorney in New York, and an expert on the Espionage Act. He's engaging in a study right now, a book. He claimed the first ever real history of the Espionage Act in book form. And Shenkman had talked yesterday about a lot of previous cases, but the cross-examination by Claire Dobbin had been interrupted because they ran out of time, and it was resumed today. And it was quite a session, and it's a lot to digest here. I'm going to do my best to summarize it. The key points are that Claire Dobbin, the prosecutor, was again saying very clearly now that the Section 793E of the Espionage Act does not preclude the arrest or the prosecution and arrest of a journalist for having unauthorized possession of classified information or defense information and or disseminating it. Just having it is enough to be charged under the act. He was trying to simply establish that, but by doing that, they have given up the pretense that Assange is not a journalist and that this is not going after the mainstream press. This is not something, that threatens the mainstream press. I mean, because this is the only thing that I've been saying all along since the first indictment came out right after Assange's arrest in April 2019. That's the only thing they really had him on. That's technically still on the books. It's in the Espionage Act. Of course, most fair-minded people who study that realize that conflicts with the First Amendment. It shouldn't be in the Espionage Act, but it's never been successfully challenged in court to have it removed from the act. But this inherent conflict with the First Amendment runs through the entire history of the Espionage Act and the many, many cases that Shenkman brought up and that Dobbin discussed with him in this very intense couple of hours of testimony in the afternoon here on Friday. She was trying to establish that journalists can be prosecuted under that section of the act. And as a layman myself, I would have said yes. And she was looking for a yes or no answer. And it seems on the face of it, we would say yes, because it doesn't distinguish who would be liable. Any person who, anywhere in the world, by the way, because of a 1961 amendment, which made this a universal jurisdiction, not just a U.S. territory, anyone can be prosecuted for unauthorized possession of defense information. So, I would have said yes, but this is he's a lawyer, Mr. Shenkman. He's quite a lawyer, and he outlawyered her, and to some extent, I think he would simply not give her an answer, yes or no, that that's the case. He said that it was not simple, and that there were there's lots of case law that he cited, and also scholarly opinions to show that that's not so simple. Uh, she brought up the Pentagon Papers case. Now, that was 1971. The New York Times and the Washington Post have been given injunctions not to publish any more of the Pentagon Papers, and they stopped and sued. And within a few days, it was rushed to the Supreme Court, and the court ruled. The majority opinion was that the government could not exercise prior restraint. That is not, they cannot tell a newspaper or order a newspaper not to publish them. However, there was dissenting opinion in that case, which said after publication, the government could prosecute a newspaper for publishing defense information once it was published. That goes back to 793E, which is that anyone who possesses in an unauthorized way defense information and or publishes it can be prosecuted. So that possibility was there. And in fact, we do know that Richard Nixon impaneled a grand jury in Boston to go after Hendrik Smith and Neil Sheehan of the New York Times, the two reporters on the Pentagon Papers case. And it only collapsed when Ellsberg's phone had been tapped and his psychiatrist's office had been invaded by the plumbers to try to dig up dirt on him. But Nixon went pretty close to prosecuting a newspaper there. Um, so, so Dobbin was trying to use that dissenting opinion to say, isn't it true that the government can prosecute a journalist based on what was said in the court? And again, Shenkman did not give a very easy answer. He was quite argumentative, and it got pretty heated between them. He was simply saying that that case at the time, the New York Times Pentagon Papers case, was the focus of the case was prior restraint, not this issue, and it wasn't argued in that case, so he didn't want to comment on it. It wasn't argued. That wasn't. He doesn't even know why those dissenting justices put out that bit of information, but it basically warned Mike Gravel, Senator Mike Gravel, to whom Dan Ellsberg gave a copy of the Pentagon Papers to put in the congressional record the very night before the Supreme Court decision that we're talking about. Gravel was in the basement of the Capitol, and he read the papers, broke down crying while doing that. And that also led to another case that came up in today's testimony, the Beacon Press case. Now, Gravel brought the papers to Beacon Press, a small publisher part of the Unitarian Church in Boston, to publish as a book. And Gravel knew that he was protected by the speech and debate clause on the Senate, inside the Senate or anywhere where a legislative act is taking place. He could talk about anything he wanted to, any class of information, could not be questioned about it, could never be arrested. But once he went outside the legislative act to publish this classified material, the Pentagon Papers, as a book, he was liable to prosecution. Nixon decided not to go after a sitting senator. But we heard from Shenkman today the details of what happened with Beacon Press, that the FBI was sent there. I knew this from Mike himself, Mike Gravel, who told me about it when we worked on a book together in 2008. The FBI was sent there and almost bankrupted this small publisher. And this was a point he also made, Shenkman, that it wasn't necessary, because Dobbin at one point tried to say, well, the fact that there's never been a prosecution before this kind of contradicts the whole purpose of their indictment of Assange. But she said, because there has never been a prosecution of a journalist before under 793E, means that the government has exercised restraint until now. And he disagreed with that. In fact, he disagreed with everything that she said. And he said no, because even if there's not been prosecutions, it's had a very adverse effect on journalism. Many newspapers, the ones they went after, were almost bankrupted because of the legal fees, and it sent a chill throughout the industry that they know the government can go after them. And the reasons the government, U.S. government's gone after newspapers throughout the whole period of the Espionage Act is because uh, those publications opposed the policy of the administration or the administration itself, or revealed misconduct by government. So I mean, how is this different? One must ask, from any tin pot dictatorship where they shut down media because they reveal wrongdoing or because they write things that the leader doesn't like about themselves. I mean, this is reminiscent of the 1798 Sedition Act of Adams, second president, who didn't like what was being written in these pamphlets. And of course, it only lasted until the end of his administration. Jefferson had it repealed and refunded the fees, the fines, rather, than people who were charged under it. But I mean, it's the same spirit of that you are not supposed to expect in the so-called democracy that the United States touts itself as, and Great Britain does too. And he talked about a couple of other cases I think are worth mentioning. A black newspaper, African American newspaper, Chicago Defender, FDR, when I sent the FBI after them, and tried to charge them with conspiracy. Then there's the case of Amnesia, which is an interesting one. This is a publication that had only about 2,000 readers, but was widely read inside powerful circles in Washington, and that after the Second World War, there was a debate in the State Department amongst the China hands, the people on the China desk, about how to what U.S. relationship with China should be with Red China after after the revolution in 1949. And the debate was so fierce that some members, some State Department officials, leaked documents to this small publication, Amnesia, to bolster their case in this internal argument at the State Department. And the government went after them and tried to prosecute them and also accused them of conspiring. And Shenkman wisely pointed out that this were elements, because he was asked by Dobbin that the case that we're hearing today against Julian Assange has nothing to do with any of these. And he vehemently disagreed with that. He said that they were trying to establish conspiracy between the editors and their sources. And in the Beacon Press case, he saw a similar WikiLeaks in that just the way WikiLeaks is trying to create a library of documents that the public has a right to know, secret documents, that Beacon Press was trying to publish the entire 4 volumes of the Pentagon Papers that Senator Gravel brought to them. So he saw lots of similarities in this constant theme of going for political reasons, going after publications, large or small, that threaten an administration. At one point, when he talked about Beacon Press, I think, is when Claire Dobbin said that this is frivolous and nonsense. It got really testy there. At other points, Shenkman was telling her, I don't want to tell you how to do your job, but, and we're wasting the court's time and my time. And this is not relevant to what my testimony is. And I don't know what your line of questioning. At one point, he said, I know where you're going with this. You're going to try to ask me this, and let me answer it right away. And Vanessa Barrett cut him off and said, let the question be asked first. So it was highly tense exploration of various cases. Another one I should mention is the Morrison case. This is a man who was working with the Navy, and he leaked some photographs that were apparently classified to Jane's Defense Weekly in the UK, not to the Soviet government, not to China, but to a newspaper. And he was arrested for that. And his argument was that he had First Amendment protections because he was just leaking to the press. And the Judge Russell was the lead judge, I guess, because he said that he did not have First Amendment protection rights, that it would be an abuse of the First Amendment, that he had no right to give those documents away. He was a government employee, and of course, he was charged under the Espionage Act. He actually served 2 years, if I'm not mistaken. It was only on redirect, rather, that the defense attorney, I think it was Summers or Fitzgerald, I'm sorry, I don't remember, pointed out that the other 2 judges on this case, there were 3 judges, wrote a dissenting opinion saying that they didn't agree with Judge Russell, that there was no First Amendment defense here. So this type of argument was underscored what Shenkman was trying to get across while he held his phone to his face because the audio was bad, that these are not simple open and shut cases, black or white, that there's enormous dissent and disagreement within the legal community, within academic community about the meaning of these Espionage Act prosecutions of the media. There have been a whole slew of them. None of them have gotten to the point where we are with Julian Assange. And that fact, even though Dobbin tried to say that proved restraint by the government, but that fact is destroyed. That argument is destroyed by the fact that this prosecution has gone forward against Julian Assange, and this is what makes this so historic. There's never been a case like this of a journalist being, and they are admitting basically he's a journalist because they're saying, and I thought correctly that the Espionage Act allows prosecution of a journalist because of this unbelievably broad, and there was a huge argument over the vagueness and broadness of the Espionage Act. Is so broad that anybody who comes in possession of classified information, that means if you download a WikiLeaks document that's still considered classified and you email it to a friend, you have essentially broken the law as well. And Dobbin tried to argue that Morrison, in that case study, it was established that the government would not go after people like that, but only certain people who were really damaging. That damage to the national security interests of the U.S. had to be proven. But again, that's not what the Espionage Act says. This is what law in cases that dealt with the Espionage Act builds up over time. And this is why Shenkman was saying that you can't give easy answers to this. These are no binary answers to these questions. No legal scholar who's aware of this, who studies the Espionage Act, could give you the binary answers that you are looking for. There was another argument that was interesting, and that was Dobbin went after Shenkman because he apparently in his written testimony had said that the executive branch basically is writing the law on the Espionage Act because they determine what is classified and what is not classified. They determine what is national defense information, which does not need to be classified. So it is so broad. It's so broad that in this case, the U.S. government has decided that naming informants, even if there were some inadvertent ones, and totally ignoring all the testimony about the care that Assange put into it, but naming informants was the informants' names themselves were defense information, and therefore they could charge them on publishing those few names or some names that came out, despite all the efforts that were made not to publish the names of informants. So she really took issue with the fact that Shenkman was saying that in essence, the executive branch, which has no role in making law, of course, it's the the legislative branch that does that. That the executive, in essence, was making law by saying what is classified and what's national defense, because that's some of the pitfalls of this broad, confusing, incomprehensible, as Mark Summers called it yesterday, Espionage Act. The government could do basically what they want, and it's politically motivated, as we've seen from these other cases. And clearly, he's trying to say, Shenkman, that this is a politically motivated case. They made a decision at the highest levels, not at the Department of Justice, but in the White House. And the Attorney General took instructions. They already made statements like Sessions did, that they were going to go after Assange, as Pompeo did when he was CIA director. So it was very clearly laid out again, and only a very close-minded person on that bench would not understand how complex this issue is, how fraught it is, how dangerous it is for press freedom. And also, it's not been proven yet how national security of the United States was harmed by any of this. This is a key point. I think we're probably going to hear more of that in the weeks coming up. But that has not been established yet either. In fact, we saw how the people of Iraq and Afghanistan and Mr. El-Masri was harmed by the United States, and that the revelations by WikiLeaks helped this man's life and helped the public to understand what their government is doing. I won't get into the long argument that then ensued about the rules of engagement and whether, because at the end, Mark Summers, I believe, read out the testimony of Dean Yates. Yates was a 20 or 30-year reporter with Reuters. and he was the bureau chief in Baghdad in 2007 April, when the events of the collateral murder video took place, when two Reuters journalists were killed. And Yates was lied to. He later found out why, because of the WikiLeaks release of the video, that the government lied that this was a firefight, and that the pilots thought that the camera of this Reuters photographer was actually a RPG. And when Yates saw the video, just like when Masri saw the video, just like we've heard in other testimony, when WikiLeaks released matters of public interest, in making this clear in this case, what WikiLeaks does, that he understood he was lied to. And he's only recently, this year, Yates came out and he put his statement on the record in the court as testimony. Vanessa Barreza tried several times to block Summers from reading this because Assange has not been charged with releasing the collateral murder. He has been charged with receiving and obtaining and receiving the rules of engagement, without which you cannot show that that was a crime. I mean, you could look at that video and pretty much understand that that was a crime. There would hardly be any military's rules of engagement written down anywhere in the world that would say you can open up fire on civilians anytime you want. But having the rules of engagement prove that the rules of engagement were violated in that instance. And that was not known until Assange published the rules of engagement and that video. So he was able to get that on the record. It was a long, long day. Again, the defense, for a fair-minded person, I think, made certain gains. It was a difficult slog between Dobbin and Shenkman up there, and the enormous amount of case law, scholarly opinion, cases that were discussed. But she was simply trying to say that a journalist can be prosecuted under the Espionage Act. And Shenkman was saying, well, not so fast, because the Constitution is the law of the land, and that's part of this issue too. In other words, no law is really set in stone. And he even said in testimony yesterday that if these things are black and white, he'd be out of a job. That's what lawyers do. They go through the enormous gray areas in the law and try to fashion arguments. So it was a wild day in court, a flurry of activity. The weekend's upon us. The people in the court will rest, but we're putting together a weekend show for you. In fact, two of them. One we can't discuss yet because it's embargoed, but we're going to have our regular show on Saturday to wrap up this week's events. And I can announce that two of our guests are Daniel Ellsberg, the Pentagon Papers whistleblower who leaked the Pentagon Papers, who testified on Wednesday. He will appear on our show. And on the show to discuss that with him and the rest of us is John Pilger, the famed Australian filmmaker and journalist. And we've also invited a few other guests. So please tune in. That will be on Saturday. We will release the details, timing, etc., in different parts of the world. And then we have this other video. So we need that coffee. So please give us the $5 that I asked for yesterday. If you could please scrounge on this. One of our videos got over 3,000 views. All of them are over 1,000. We're not asking for all 1,000 of you, but a few of you, if you can, to pledge $5 a month to our Patreon page, CN Live. That is patreon.com/CN Live. And we will see you on Saturday for our wrap-up show. So for Consortium News and CN Live, this is Joe Lauria reporting.